Welcome back again. Ladies and gentlemen, thank you very much for joining us here again. I would like to introduce Keith Chatsauka. He is the latest member of the NETCB, or the newest member of the NETCB executive team. He will be presenting a rather interesting topic to you today, even maybe a bit controversial as well. But I will allow Keith to introduce him further. He's very well qualified, highly educated in terms of degrees. So please welcome Keith to the stage.
Thank you very much, Kwabas, for that introduction. Good morning, good afternoon, and good evening to everybody who's attending the Net.Share conference this year. My name is Keith Chatsauka. I am a mathematician, a lawyer, a cryptographer, many things. But today I am appearing as a lawyer with a bit of technical knowledge when it comes to information and communications technology law. The presentation I will be giving today is called the Wallace Line: Regulation, Compliance, and Equity in the Age of Cloud Computing. It will become readily apparent in a moment why I chose this title. All right, so appearing on your screen now as part of my presentation slides should be a map of the actual physical Wallace line. Now, this term comes from the natural sciences, and it comes specifically from Alfred Wallace, who in 1859 discovered many of the features that the people who consider Charles Darwin to be the father of evolution would have put forth at the time that he published his book on the origin of species. They were in constant contact. There was sharing of intellectual property. There was sharing of knowledge. Wallace's line is an actual invisible barrier between the Pacific and Indian Oceans, as well as Australasia on one side and Papua New Guinea, and then the island of Borneo on the other side, that dictates what kinds of life can exist on either sides of the line in the Malay archipelago. All right, so as you can see on your screen, there is a red line that cuts through Lombok all the way through to Celebes Sea, and this demonstrates a very interesting dichotomy. The types of life that you find on the Australasian side, where Papua New Guinea and most of the Pacific Ocean is very diverse and very different from what you find in Sumatra, Borneo, and the other surrounding islands that are on the other side of the line. Today, the Wallace line will be serving as a metaphor for compliance and regulation when it comes to cyber law. Because we deal in information systems, information security, and information technology, it is of the utmost importance that we always keep in mind that we are not just serving machines or servers. There are actual physical customers that are sitting who have interests and rights that need to be protected and promulgated all around the world, despite wherever you may be as a service provider, as a vendor, or as a supporter of certain vendors' products. Coming back to the natural sciences once again, just to use another analogy, we come back to the P is equal to NP problem. Now, this is an unsolved mathematical problem, but it can also be described as a philological problem. P equals NP assumes that the value of P represents a problem, and this is still unsolved to this day, ever since it was postulated as a mathematical question. P's NP basically proffers that for every problem, there is either no problem because you solve it yourself, or there is a problem and there is no solution. And because P equals NP is both solved and not solved in this state, i.e., if you have developed a solution for yourself, then P equals NP means NP becomes your solution. And if P is still solved, but solved through other people's means, then you have to accept their explanation for why the solution is the way it is. It brings us to verification and solutions and creates a dichotomy. Either you create a solution or you're forced to defer to the understanding of others. This creates a zero-sum game. In mathematics, a zero-sum game is a position where nobody in a closed system can make gains or losses without another part of the system making gains or losses that are approximate or equivalent to the gains or losses of the other party. Now, bringing this back into the field of law. For reference today, we will be referring to the Budapest Convention on Cybercrime, which was adopted by the Council of Europe in 2004 and went into effect then. Although, as it will become readily apparent by the time we get to the end of the presentation, not everybody has adopted the standards that were envisioned in the Budapest Convention on Cybercrime. And so, to this day, there are still countries that are becoming signatories and ratifying the Budapest Convention on Cybercrime. It has become an important international standard that helps guide countries whenever they are making legislative decisions about how to enact privacy protections and to regulate vendors and creators of technological products who exist all over the world who might not necessarily immediately operate in that particular country's jurisdiction. We also refer to the Organization of Economic Cooperation and Development's guidelines on data protection, as well as two ISO standards, ISO 17799, which is the Information Security Management Standard, and then ISO 27001, the Information Security Management Systems Standard. In addition, we will be making extensive reference to the Electronic Communications and Transactions Act, number 25 of 2002 from South Africa, and the Cloud Act from the United States. I would proffer a disclaimer here. Cloud is a bit of a misnomer because it's an acronym. In this case, it stands for clarifying the lawful overseas use of data. It's just another means, another mechanism for mutual legal assistance to be facilitated in this day and age. Since the majority of technologies are based in, the biggest technological companies rather, are based in the United States, it makes sense that the United States would enact a domestic law that allows it to share information that other countries otherwise would not be able to access without those countries having to first abide by United States laws and United States jurisdiction. So partner countries, in terms of the Cloud Act, enacted in 2018, are allowed to use their domestic jurisdictional and legislative schemes to determine how to access data from anyone who is storing it on behalf of a user or a vendor or any other part of civil society. Some of the key issues we're going to be discussing today concern the jurisdiction and the application of laws. Application of laws becomes an issue whenever we contract across borders, and that will be dealt with in more detail in the next slide. Now, when it comes to forming a contract in this day and age, click and accept and click wrap and shrink wrap contracts have become the norm. And those are not without their own problems. So we will come back to that in a later slide and we will address it in more context then. But for the formation and validity of contract in this day and age, it is simply required that the contracting party who sends the contract to another or makes an offer to another receives a valid acceptance of such an offer. And once that acceptance is received by the original offerer, this then makes a contract come into existence, with or without signing actual documentation. As it will become clear as we go through this session, contracts can be formed by any means, really. Anything from an SMS has been held by the South African courts to constitute a valid means of accepting a contractual obligation or creating contractual obligations. but we will come back to formation and validity of contract. We briefly also touch on electronic data interchange, which is the use of any electronic system or any technological implementation to automate parts or all of the part of the process of putting together contractual relations between people contracting as they are not in the same jurisdiction. Let's delve a little bit more into those transborder legal issues I had briefly alluded to before. With reference to real-time transactions, there are always requirements that are put on both contracting parties, depending on what their legislative scheme is, because we do not exist in a singular, well-integrated, standardized industry. Real-time transactions attract consequences for different people at different times. For contracting parties, say for example, that are in South Africa contracting with people in the UK, the laws would be similar due to the basis of our legal systems, the common law, which is applicable in most jurisdictions around the world. But if I were to contract with a country that has laws that are based on a religious outlook, for example, say for example, the Muslim practicing communities and the Islamic communities that exist in the Middle East, their legislative schemes are slightly different from what you would find in typical common law backed legal systems. And this must be taken into consideration when you offer products and services and support to people in those jurisdictions. You subject yourself to the jurisdictional requirements of the country that the customer is in as well. Let us briefly take a look at incorporation by reference. All right, so there are two types of agreements that can be referred to when we say incorporation by reference. It's click and shrink wrap agreements. Click wrap and shrink wrap agreements we usually use in electronic commerce, and we also use when we are selling software products to people who are outside of jurisdictions where they would have the ability to gain full access and the advantage of the choice of laws of the jurisdiction from which the contract is offered. Say, for example, you're buying a product from Amazon. By buying a product from Amazon, a United States company, you're binding yourself to the choice of laws because there is an election. When you click buy, you are given the option to confirm the transaction. By clicking confirm on that transaction, you have agreed to an entire contract. A contract comes into existence, but it is not yet valid. It is in abeyance. This means it is held back until such time that the e-commerce provider or the service provider delivers a product specifically to the customer. Only when the customer has the product in hand does the contract actually come into existence, and do the full obligations and benefits that attach to such contract come into existence. Shrink wrap agreements are similar, but they use a different type of trick. They incorporate other contracts by referring to parts of those contracts in the original contract. So say, for example, you have concluded a master services agreement with a particular company. Instead of renewing the master services agreement every single time you need to conclude a new transaction, all that happens is that you issue a new service level agreement, an agreement in terms of the original agreement that refers to the original agreement, the MSA. By doing this, you are incorporating all the elements that already existed and you're still bound by the master services agreement, and that contractual relationship can exist in perpetuity as long as nobody elects to break the contract or nobody breaches the terms of the contract, which will result in other legal consequences. When it comes to data storage and management, endpoint management for software vendors, hardware suppliers, and anyone else who is in possession of people's personal information, personally identifiable information, and personal private healthcare related information needs to be aware that there are certain legislative requirements that attach to them as a result of being in possession, being an information controller when it comes to that specific information. In certain states, like the United States, they have HIPAA. HIPAA is specifically for health. It's specifically for protected healthcare related information, and it is important to wrap your head around these complex legislative regimes as they attract various kinds of consequences and sanctions for non-compliance. For personal information in general, we once again refer to the Budapest Convention, and we also refer to, in a further slide, the GDPR and the Protection of Personal Information Act from South Africa. Information that is put under an information controller's control has to be dealt with as if it is the most valuable thing that the information controller has in their possession. This is because data privacy rights attached to that information, not only from the user side, but the state may impose certain legislative requirements on any information controller in order to enable them to be compelled to produce such information or to be compelled to retain such information for a certain period of time. This becomes particularly relevant as we have backup solutions that were being advertised here at net.share, like Backup Eagle and Symmetra's Zero Rights help desk system. The next point to be dealt with is related to public key infrastructure. Symmetric and asymmetric cryptography are used in varying shapes and forms, but it boils down to there is a cryptographic algorithm that takes an input key that is implemented into a wider system, which is then known as a cryptosystem. Public key infrastructure simply has two keys instead of the one key that you find in a symmetric system. In a public key system, you have a private and public-facing key, and both are used in order for you to conclude certain transactions. A key issue that comes up when it comes to public key infrastructure being used for real-time transactions and for communications and to protect such communications is key management. And this is an issue that, luckily for me, was dealt with by the previous keynote speaker in his keynote. That is also an example of incorporation by reference. So if you did not watch that session, please go back and watch that session, and this part of the presentation will make more sense. In addition to public key infrastructure and cryptographic applications in general, there is the great encryption debate. This is how we protect data that is at rest, data in transit, and data that has been decommissioned that now needs to be removed from your systems because it is no longer needed. This is a very big issue that requires many, many hours of exploration, but to condense it down into something that is consumable in the legal sense, I would simply suggest that use the best cryptographic applications that you have and make sure that they are not just recommended cryptographic applications, but that they are default cryptographic applications if you're not using proprietary materials. If you are using proprietary material, I suggest that you allow people outside your organization to do some kind of penetration testing into your crypto systems to ensure that they are compliant. For data breaches attract legal consequences too, and this can result in sanctions that result in both fines and things even as drastic as the removal of your ability to operate in certain jurisdictions. So you want to treat this as an area that requires all your attention. All right. Now we move on to cloud storage and infrastructure as a service, as well as software as a service, specifically as it relates to privacy in the digital identity milieu, this kind of environment that we're in. Cloud storage itself is not necessarily a problem. The implementation thereof would become the problem. If you do not protect people's data and a data breach happens, there are three ways in which you attach liability to yourself. Through dolus directus. Dolus directus means you have directed your will and you engaged in an action, and as a result of that action, you are now liable. Dolus indirectus or dolus in eventualis is what we commonly refer to as the reasonable person test. You should have reasonably foreseen that because you are storing people's sensitive information, you have an extra obligation to ensure that that information is adequately safeguarded and protected, and all your systems are in compliance with all the legislation that attaches to your cloud storage services in all the jurisdictions where you are operating. This differs per country. This is where NETCB comes in, because we can offer solutions by allowing you to consult with us, because we have lawyers in-house who know how to peruse legislative information and to get you the best kind of overview into what kind of system you're engaging with when it comes to operating in different jurisdictions in this day and age, and making sure that you comply with all the laws that attach to that jurisdiction. Another important transborder legal issue is technological neutrality or interoperability of the systems and software and hardware products that you may offer. They need to be able to interface with other things that exist outside of our proprietary systems that we offer as vendors and as a people who create the technologies. This may be required by law, but in most cases at this point in time, it is simply best practice. It's industry-wide best practice for you to have technological neutrality and interoperability built into both the back end and the front end of your systems. Security is both the responsibility of the end user and, more importantly, the information controller in this context. This refers to both physical security and to the security of the information and any other transactional information that attaches to the transactions that customers perform on your systems. Information security systems management becomes very important in this context. And so compliance with the ISO standards I mentioned before, ISO 17799 and ISO 27001, becomes of the utmost importance, because complying with those standards and regulations in most cases will allow you to comply with the legislative regimes and requirements of different countries around the world. Compliance in a non-standardized industry. As I just alluded to, we mostly rely on best practice and industry-wide standards and the International Organization for Standardization and any other local bureau that makes standards in a country, because these are then incorporated into legislation and you are then bound by them. They no longer are best practice. This is now a matter of required to. You have no choice. You must abide by those laws. Otherwise, you attract different kinds of criminal sanctions, which can range from just a fine all the way to serving serious jail time. So this should always be kept in mind. Now, because we're at the forefront of technological evolution, we are always on the bleeding edge. And compliance can never keep up with the kinds of products that we are developing. A case in point is the introduction of crypto systems specifically for financial transactions, looking at Bitcoin and Ethereum. Now, because these particular types of crypto systems are fulfilling the functions of financial service providers, they attract their own kind of consequences. But because the regulators have not yet gotten to the point where they understand the technologies that are being used enough in order to regulate, we once again fall back on best practices and industrial regulation, industry body regulation, in order to make sure that we are compliant with the general legislative scheme, but we also anticipate the specific laws that are going to be enacted to deal with certain products. Tips and tricks, choice of laws. The simplest way to deal with a choice of laws conundrum when you are contracting with customers who exist outside of the country that you primarily reside in or you primarily operate in would be to be found in your own country, because those are the most accessible laws. And once again, because NETCB now has a compliance division, we are able to offer these services to you, and we will do the hard work of going and sitting and sifting through your entire legislative framework, finding the laws that apply to you, creating legal questions around them, and then we give you the ability to comply with them, and we give you reasons why it would be in your best interests to comply. So the tip is actually mostly stick with the jurisdiction that you are in. Computer crime has become abhorrent. It is horrible in this day and age, be it card skimming, be it jamming locking devices on cars, be it compromising critical information and communications technology-based systems. All of these things are now of paramount concern to anyone who is working in our space in the ICT industry. Traditional IT itself comes with the known quantities. Say, for example, somebody gains physical access to your premises and you do not have enough physical controls in place, then that makes it more likely that the threat actor is going to be able to steal valuable information and or other related data. And this must be mitigated because, as we have already seen, this attracts legal consequences and sanctions. For data in transit, across the traditional IT network infrastructure, if you're doing this over cables, it's susceptible to packet sniffing because somebody can simply place a tapper on the line and they will be able to see more or less what is being sent, the network traffic that is being sent and received across these cables. Same thing applies to the wireless standards. If the right person is listening at the right time, they can pick up on communications. So it is of the utmost importance that we make sure that information and information system security is always up to par. There are additional regulatory requirements that attach to people who provide specific kinds of services. For example, if you want to develop cryptographic applications using the South African legislative regime as an example, in South Africa, you are required by the Electronic Communications and Transactions Act to register as a cryptographic application provider. And this entails several different things that, should you need them, we will be ready to assist you with. But each country has its own makeup and its own regime that governs how they treat all these different interacting, interconnected systems. So it is best to always ask before you implement your system, as opposed to you launch a product or a system and then you realize that it is not compliant not only with best practice, but with the actual jurisdictional laws that apply to you. The international overview of traditional IT is rapidly changing. Most people are migrating towards hybrid systems that use both cloud computing and traditional IT infrastructure that is stored in a physical data center on premise. Speaking of cloud computing, the concerns do not stop with the traditional IT environment. Dissemination of information when it comes to cloud computing once again makes the person who is the recipient of the information an information controller. Information controllers are bound by laws across any country that you can think of, to the point where, case in point, the Ministry of Information Technology in India promulgated regulations last year that would allow them to compel all cloud computing service providers in India specifically to comply with the request for information from law enforcement and national security agencies. It is important to make sure that the information you hold on behalf of other people, that is, information in escrow, is dealt with in a manner that is befitting of sensitive information. If the information that you have on hand is breached and you do not notify customers, and your customers may be all across the world or limited to one jurisdiction or even one province or one city, and you do not notify them, this may result in class action suits against you, potentially exposing you to millions and millions of rand worth of damage, or whatever local currency you're operating in. So it is important to always make sure that any information that you hold on to in your role as an information controller, information you come into possession of by virtue of the operation of your products and services, is treated as the most important asset that you have, because it also attracts the biggest consequences should you not. Finally, we have all heard about third parties exposing particularly big companies and organizations to data leaks and data breaches. I can think of SolarWinds that happened in 2016, and I can think of the Sony network outage that happened in 2011, 2012, as a result of the hacking group Anonymous. And both these examples demonstrate that when your customer base is no longer centralized and they're decentralized and they're spread all over the world, it is important for you to comply with all the legislative requirements in order for you to not have any kind of intermediary liability attached to you. Intermediary liability is something we'll deal with in one of the following slides. And so, not only do you have to manage the information that you have as an information controller, you must also make sure that your supply chain processes and supply chain management is risk management compliant and mitigates as much risk as possible to ameliorate the chances of you finding yourself in the middle of a class action suit for which you may be on the hook for hundreds of millions, if not billions of dollars. All right. In general, this is a non-exhaustive list, but this is a list of some of the more important data privacy laws and international privacy instruments. So specifically relating to data privacy, we have the Cloud Act, the Clarifying Lawful Overseas Use of Data Act, which simply allows mutual legal assistance treaties and all these other legal instruments between countries to be enforced using that specific country's laws instead of the United States laws, if you are somebody who is performing a function in the United States, or if you're primarily or ordinarily resident in the United States. We also have the General Data Protection Regulations from the EU, This has formed the basis of most of the protection of personal information acts that have been enacted by individuals outside of the EU. For example, in South Africa, we have the Protection of Personal Information Act, as I just stated. And then we also have the Electronic Communications and Transactions Act. And this attaches other consequences as well, in addition. Now, in terms of the Cybercrime Act, this specifically attaches to people who are, once again, information controllers, the perpetrators of cybercrime, and it also offers certain remedies to the information regulator in our particular South African environment. It allows you to be able to go to the information regulator when an information controller is non-compliant with the requirements of any of these three acts: the Protection of Personal Information Act, the Electronic Communications and Transactions Act, and the Cybercrime Act. And you can get some sort of relief directly from the information regulator themselves. Now, for the multi-jurisdictional transfer of personal information, this attracts consequences as the information passes through each jurisdiction, because each jurisdiction that the information passes through will have its own legislative scheme, and it is our responsibility as the ICT industry to make sure that we are knowledgeable about what these requirements are and that we are compliant with them. NETCB is happy to announce that we also will be able to offer these services in-house. So should you have any concerns, please visit our booth and you can set up a meeting and we will be able to talk it through and figure out a plan of action and how to make sure that you are compliant in all the jurisdictions where you store or you transfer data through. If you have nodes that exist in a particular country, even though you did not alert end users that you were going to be storing information there, you must make sure that you are complying with that country's legislative requirements as well, even though your company may not be physically registered there and it may not be ordinarily resident there for tax purposes. This is important because once information is stored in that particular country, it is subject to the entirety of the legislative regime. And so, if it is requested by that particular country's information regulator, it must readily be available. And end users are entitled to know, in terms of law, where their information is stored. If you do not specify that you're not going to store this specific information you collect from them in a particular place. So if you do not have a waiver clause in your click wrap or shrink wrap agreement that specifically disclaims and disallows claims that information is not going to be stored anywhere other than where you said it was initially going to be stored, you may find yourself in legal trouble once again. This is something that CB can help with. It's part of our expertise now, and we are very happy to be able to offer this service to all of our customers and clients. When it comes to disclosure requirements, this is once again regulated on a jurisdiction-to-jurisdiction basis. There is no basic template that you can follow. It must be dealt with in the context of the jurisdiction that you are going to be storing the data in, or the jurisdiction where the data comes from, or alternatively, the jurisdiction where the contractual relations are officially registered, i.e., where the contract was executed and came into existence. That is something that CB can also help with. When it comes to cookie and tracking technologies on our websites, in order for us to store certain configuration settings for users so that they do not need to reconfigure every single time they access certain services or websites, it is generally best practice to make sure that your cookies and your tracking technologies are compliant with the Protection of Personal Information Act here in South Africa, the GDPR in the EU, and the United States Cloud Act and the Stored Communications Act as well in the United States. Moving on from cookie and tracking technologies, The next evolution of cookie and tracking technologies is federated learning of cohorts, as introduced by Google last year. Now, federated learning of cohorts entails learning basic identification characteristics that relate to individuals, grouping them together, and then using that to manage their preferences and figure out what they like and what they don't like, as opposed to using cookies and currently proliferated and widely available tracking technologies. It has yet to be tested in a court of law whether or not federated learning of cohorts actually is something that would be legally permissible. But that is something we will see once again at the end of the presentation, that it's an ever-changing environment and we need to make sure that compliance is number one on our priority list, because without compliance, the rest of the business cannot exist. The implications, therefore, for us as people who are vendors and suppliers and partners to vendors is that we want to secure this information on behalf of end users and on behalf of our customers. But at the same time, there are privacy concerns that end users would have, and these privacy concerns relate to the dissemination of their information. You have the right as an end user to control what information about you is available and how it is shared with anybody else, if it is shared at all. Our primary concern is with security. We need to find a middle ground, because at the moment, this is a zero-sum game. For every gain we make towards achieving some kind of data privacy, we're sacrificing security, or vice versa. This cannot be. It is not acceptable. So that is food for thought. Cybersecurity in the cloud computing age has become very complex and very convoluted, and we are happy at NETCB to be able to offer you the expertise and to let you know that we have the requisite knowledge to deal with all of these questions on your behalf and to make sure that you are in full compliance wherever you are, 24/7, 365 days a year. Intermediary liability is a very long topic, but essentially we differentiate between hosts, caches, and mere conduits. Conduits are people who make it possible for you to send information from location A to location B. Caches are people who store information temporarily until a particular transaction is concluded, and hosts are people who hold on to information for a little longer or indefinitely on the basis of a request by an end user. And in all four of the jurisdictions that are currently highlighted on this slide, this differs, but for the most part, most liability attaches to hosts, and caches and conduits have varying levels of intermediary liability. In the digital property space, where we now find ourselves with the ability to own things that do not physically exist, the law had never anticipated that we were going to have ownership of non-tangible things. But immaterial property and contract and those particular fields of law are now developing rapidly to ensure that we can catch up and make sure that we protect everybody who owns any kind of digital assets. I can see that I only have 2 minutes left here. I would have discussed the Unity scandal that happened earlier this year, whereby Unity, as an engine for manufacturing video games, wanted to charge end users a fee for each time that they launched any game that was created on their platform, that is based on their platform, each time that they reinstall the game on a new machine. That would also have brought up several legal consequences, but unfortunately, we're not going to have time for that now. I will make this slideshow available together with the links that I would have shown during this part of the presentation in order to mitigate any loss of information from this part of the session. With regard to cryptographic applications, we already discussed that certain jurisdictions require you to be a registered cryptographic application provider, and that attracts consequences by itself. Come in booth for a consultation, and we will be able to tell you whether the jurisdiction that you operate in, or all the jurisdictions that you want to find out information on, require you to do anything in that regard, and if so, what. And so I would have also covered the fact that Alfred Wallace is also the father of evolution, as based on the diagram that I showed you before. He proved, before Charles Darwin published his book on the origin of species, that evolution was a thing by doing biogeographical mapping and showing that different species that reside on different parts of the planet have different developments that happen to them specifically as a result of their environment. But credit is given today to Charles Darwin because he is nobility, and, well, that happens often. Sir Francis Galton is the same. So instead of doing that and stealing other people's intellectual property, we should ensure that actually we protect it, and we promote digital rights management, and we promote privacy rights, and we promote encryption, and we promote the customer's best interest, because this protects you from any kind of legal exposure. Thank you so much for tuning in for this Net.Share presentation. I'd like to thank everybody who helped me put this presentation together, and I will make additional information available, and this entire slideshow itself will be shared with you after the Net.Share conference concludes. That is all from me today. Thank you so much. Enjoy the rest of your day or evening, as it may be.